Legalese. At Kaminsky Law, one of the main focus areas of our practice is company disputes and arguments or disagreements between partners or members or shareholders of a company. Ideally, there will be an agreement that talks about each shareholder's rights and each shareholder's responsibilities to the companies, what everybody's contributing, and what their roles are. However, that is not always the case. More often than not, we see that two partners go into a business 50-50 and have a verbal agreement. One of them says, I will take on these roles, for example, marketing, or I will be the office manager. And the other person is supposed to go and develop business or is supposed to do the actual work. They have this agreement verbally, and most often they operate just fine for years on years. But we usually get involved when there's a problem. One of the main problems we deal with is shareholder oppression. That's when one of the partners decides that the other partner is no longer needed, and they start taking away their responsibilities, they start taking away their access to the business, and they start taking away their ability to do things in furtherance of the business. One of the ways Pennsylvania defines shareholder oppression is when one shareholder frustrates the reasonable expectations of the other shareholder. What does that mean? When people go into business, they usually expect that to be their work. So if one person is then kicked out of the office and told that they can't come in and stop receiving a paycheck from the business, well, that would frustrate their reasonable expectations as an owner of that business. Another way that a shareholder can be oppressed is if the controlling shareholder doesn't let them make any decisions, doesn't want to give them access to financial information of the business, and tells employees not to deal with them. The question we hear most often is, we are 50-50. Can a 50% shareholder be oppressed? Pennsylvania law says yes. Even a 50% shareholder can oppress a different 50% shareholder. The question is usually less of a question of how much percentage do you have and more of a question of control. So if a 50% shareholder has the control of the business, has control of the bank accounts, has control of the email accounts or the company phone, it becomes much easier for them to just exclude the other person from it. If they are excluding the other person from it, refusing to share information, and again, frustrating their reasonable expectations, that can constitute shareholder oppression.